living with DOMA since 2004, 2005. Most of them married, and it's been causing them harm every year. Harm concretely in terms of protection denied, but also harm by really putting a stain on their marital status and telling the rest of the country that they are not married and making it harder for them to live their family lives. So we are very grateful to have had today's day in court.
Mary, did you get any sense as to how the judge was analyzing all this based on the questions he was asking?
The judge was clearly prepared, and he asked good questions on both sides, and I think he completely understands this case. So, and there's a further argument on the 26th in the case involving the Commonwealth of Massachusetts, where they are making a separate claim, which is that there's simply no power for the Congress to enact DOMA at all. We're saying even if there is a power, it violates the equal protection guarantee because it's treating just this one small group of married people differently from everyone else with absolutely no justification. But they are raising a question about whether DOMA belongs on the books altogether at all.
The attorney for the other side made a point of saying that the administration does not support DOMA, wants to see it repealed. Did you feel that there was gusto in his argument that he was doing it
in his argument?
Yeah.
Frankly, the Department of Justice is defending this case. The United States of America is the most powerful defendant anywhere. And they are insisting on the rational basis standard, where you're allowed to make things up after the fact that might just be conceivable. So we don't view the defendant's defense of this case as half-hearted in any way.
Well, what are the next steps for you? Are you just sort of a waiting game at this point?
It is the waiting game, and we have no idea how long it will take this judge to issue the decision. Clearly, he was prepared. He's already engaged with the issues.
Mary, do you agree that the administration, as the Department of Justice has said, does indeed want to repeal this and is doing this because it is obliged to do it, or do you feel that that is a legal nicety?
Well, the administration made a point in the first brief that they filed that they do view it as their duty to defend the constitutionality of statutes because you don't want a situation where one administration supports a particular law, it's later challenged, and then that second administration later on says, well, I disagree with that law, so I'm not going to defend it. That it's really a question for them of institutional integrity to continue to defend the constitutionality of statutes. So that's what they've done here. And all I'm saying is I don't view them as rolling over.
Do you think that some of these benefits to custody and health, paying for your health care, are those federal rights, constitutional rights?
What we're dealing with in this particular case is statutes where there are protections available to married people. There's 1,138 federal laws where protections are provided or responsibilities are imposed, or there's things like being able to just invoke a spousal privilege in court that you can't make one spouse testify against another. And what we're saying is, given that the federal government has already made this decision that these are protections for married people, why is just this one class of married people being singled out? And we say that DOMA is a completely unprecedented law. The historical record is that is true. It's nothing like this has ever existed before. Scott Simpson agreed to say as much. 1996 was the first time there was a federal definition of marriage. And we say they did it for all the wrong reasons, only because they knew, or they thought at the time, that same-sex couples would marry in Hawaii. And they wanted to put their foot down and say, not for gay people. The other thing I wanted to do is I want to make sure that you all know that standing behind me right here are all the amazing clients who are in this case, every single one of whom is qualified for a particular federal protection, applied for that protection, and was denied, not because they weren't qualified, not because they hadn't been married long enough, not any of that, but only because of DOMA. And so with respect to the tax plaintiffs, they are all effectively paying a penalty every year in terms of paying higher taxes than I identically situated neighbors, friends, and colleagues with all the exact same circumstances. They are paying more every year. With respect to the Social Security plaintiffs, including Herb Burtis right here, who was with his spouse for 60 years, 60 years before his spouse succumbed to Parkinson's. You know, in Herb's time of need, having lost his spouse, what happens? The Social Security Administration pulls out the Social Security safety net and says, you are not qualified for a survivor benefit, even after 60 years. But you've heard me talk about Nancy Gill, and you heard us talk about Dean Hara, but there's Al and Jim are here too, who, sorry, Al Koski is a retired Social Security employee, and again, they still can't get health insurance and other benefits, forcing Jim to continue to work when Jim has severe asthma and really needs not to be working. And all other spouses of federal employees have access to that basic benefit. And as I asked at the beginning of the case, what is the purpose for the United States as an employer to say we're going to treat all married people, all married employees one way, but not just as one group of married employees? In the end, DOMA is a blatant double standard, and we know why it was enacted. It was enacted, as Representative Henry Hyde said, it was enacted because of the disaffirmation of gay people, and the only way they could express that was through the law.